Thank you for joining us for our second episode in the SLW Quantum Computing webinar mini-series. Today, we will be presenting patent prosecution strategies in quantum computing. If you missed our first episode of the mini-series, our presenter will recap the material in a few of the slides, but the full recording is available under the webinars section of the SLW Institute at slwip.com if you are interested in a deeper look at the quantum technology stack. My name is Dr. Laura Kinnischtzke. I will be moderating today. I'm a patent agent here at SLW, and I earned a Ph.D. in physics from the University of Rochester before transitioning into patent prosecution. Today's webinar will be recorded, and a link will be sent to both the recording and the slides for everyone who registered. We also will have a link in the chat where the presentation slides will be posted online for you to view during the webinar. If you would like to ask questions, our chat feature is open in the Zoom menu. We can address the questions either during the presentation if it's super relevant to what Matt is presenting at that moment, but there will be a fair amount of time at the end for questions and discussion as well. Our speaker today is Matt Norwood. Matt is a patent attorney here at SLW. His practice is focused on preparation and prosecution of patents before the USPTO. He has experience in a wide range of industries, including artificial intelligence, robotics, process automation, non-destructive testing, telecommunications, semiconductors, silicon photonics, optics, and more recently, we have worked together with some quantum computing clients. And with that, I'll turn things over to Matt.
Great. Thanks, Laura. Um, so, as Laura said, she led a webinar a few weeks ago that was amazing. Part one of our little mini series here, where she went through all of the technical details of the sort of quantum technology and the quantum computing stack. And so we're going to start today with just a brief recap of some of the subject matter that Laura covered in episode one. Then I'm going to try to give a really quick snapshot of kind of the patent landscape in quantum technology, who's filing what, where, how much. And then we'll take a look into the sort of meager amount of case law that we have on how these patents are getting treated, specifically at the PTAB, at the Patent Trial and Appeal Board at the United States Patent and Trademark Office. And that might give us some insights into sort of how the law is shaping up, how these technologies are likely to be treated when they're the subject of patent applications. And then hopefully from that we can sort of distill some principles that might guide our own practice as patent practitioners from that case law, that jurisprudence, but also some of the personal experience that Laura and I and other colleagues have had kind of dealing with these technologies from the standpoint of patent practice. And then for the last section today, I want to dive into some specific concrete case studies of actual patent applications that are filed on different parts of the quantum technology stack. And before all the in-house people freak out and log off because they think we're about to splash their competitors' patents on the screen in front of them, everything we're going to cover is, let's say, priority dates from the last millennium. So these are old filings that, no legal advice here, but these are dead applications. And that makes them more interesting in some ways because these are some of the foundational technologies when they were first being filed in the late 90s. But they might give us a little bit less insight into how people are drafting their patent claims today. You want to find out about that, you're going to have to do your own research. So we'll jump in then and start with this recap of what Laura covered a couple weeks ago in her presentation on the quantum technology stack. So Laura first introduced us to some sort of core concepts in quantum mechanics. There's the concept of superposition. This is where a qubit, a quantum bit, can exist in a combination of a zero state and a one state at the same time. There's the concept of interference, as in positive and negative interference. This is where you have quantum states that combine like waves with their amplitudes adding or canceling out. And you can use this interference to sort of steer computation, toward correct answers. There's the concept of decoherence, and this is the sort of a constraint on quantum computing, where any interaction with the environment causes the qubits to collapse, lose their quantum behavior, and this kind of acts as a constraint on computation time. And then there's the concept of entanglement, where you have two or more qubits that become linked so that the state of one is correlated with the state of the other, even if they're separated by a significant distance. And all these concepts that can be sort of leveraged to, accomplish different practical applications. And so Laura then went over some of these sort of general areas of application. The first being communication, where you can use quantum cryptography or other techniques to establish secure networks that leverage some of these quantum properties. There's the field of sensing and metrology, where you can actually leverage the sort of fragility of these quantum states and their tendency to collapse, decohere, uh, to perform ultra precise measurements of the environment. And then the third big area of application, and what's going to be our primary focus today, is quantum computing, where you're solving these computational problems through manipulating these complex, multi-qubit probability spaces. So we went over, again, last time, the quantum computing stack. And this is a bunch of different, discrete technologies that are all combined together to perform quantum computing. And so starting at the bottom, at kind of the level of materials science and physics and almost mechanical design, let's say, is you have to have an actual physical implementation of these qubits that are going to be some kind of matter maintained in a quantum state. So you have a quantum processor or quantum registers that actually physically embody the qubits. That's at the bottom of the stack. Then at the next level up, you have some kind of enabling hardware or control systems that will control the quantum processor, um, adjust the data, read the data, um, protect the quantum processor from interactions with the environment, cryogenics, stuff like that. And the control systems and communication systems here are essentially going to be analog electronics that are controlling and communicating with the quantum processor using analog electrical signals. Then at the next level up, we have error correction. These quantum processors are inherently very noisy, and so a lot of effort goes into cleaning this up, converting it into a binary format that can actually be relied upon. Um, and then at the top of the stack, we have sort of the software and application space where you're using classical computing hardware and classical computing algorithms to set things up and get the analog components of the system to talk to the quantum processor and sort of form an interface between the classical realm and the quantum realm. So from an IP standpoint, we'll go this time from the top down in the stack. Up at the top, layer 4. So these are the classical algorithms and software applications that you're using to actually solve problems. So from a patent standpoint, you're going to have inventions around clever ways of sort of tailoring quantum routines to specific industries or known computational problems. At layer 3 of the stack, you're doing error correction. You have these inherently noisy qubits. This error correction and more generally a sort of translation part of the stack that turns this sort of noisy, unreliable hardware into something that a programmer can actually make use of And so a lot of patent activity here revolves around how to correct errors, um, and specifically how to correct them, without sort of collapsing the computation. Um, at layer two, these are the control systems, the enabling hardware, the signals, timing, measurement, and also just supporting hardware that talks to and preserves the state of the qubits. So patent activity in this layer is often going to read on sort of how the signals are shaped and sequenced, and a lot of other sort of signal processing work. And then finally, at the bottom layer, where you have the actual quantum registers that embody the qubits, here you have this physical hardware that are the qubits themselves. And there's a lot of, I mean, a huge amount of work here, driving fundamental innovation in material science, in photonics, all kinds of real heavy duty physics and material science and chemistry here for different physical implementations of the qubits. So that's a very, very quick snapshot just to remind everyone of what we covered last time. And so I now just want to very briefly talk about the landscape of who's filing patents, where, what do things look like from the big picture. So there's actually been quite a few really, really nice reports published in the last few years. This is a quotation from a study last year out of MIT that kind of gave a nice snapshot of the whole quantum patent landscape. Um, what are my pull quotes? Quantum technology patents grew fivefold from 2014 to 2024. So there's real explosion in patenting activity here, even though, as we'll see, people were filing on stuff in 98, 99, 2000. Second quote, corporations hold 54% of these and universities 37% out of the total filings to date. But on the next slide, we're going to see an interesting complication there. And then the third quote I pulled here is that China is in the lead currently with 60% of the patents as of 2024. Behind them is the US and then Japan at the national level. So this question about corporate versus university filings. It's true that the number of corporate patents is overall higher, but what we're seeing in recent years is that I think as some of the groundwork has been laid in the very capital intensive development of some of the sort of core tools, this has, I think, enabled academic research to really take off. And what we've seen in the last few years is the number of university filings has actually surpassed the number of corporate filings. So that's interesting and should inform some of our tips later on. Okay, at the national level, as we said, China out there ahead, especially in the quantum communication realm. The US is behind and is in fact has a significant lead in quantum computing as opposed to communication. Europe as an entire region is kind of then in third place there, and both Japan and Korea have very strong showings. So that's sort of an interesting set of dynamics there between the US and China, which each have a lead in a specific subfield here. Um, I I'm broadcasting to you right now from Canada, which I have to say, little plug, is punching above its weight, but it's a very small country. It did not make the top five here. And in fact, who is doing these filings specifically? Again, top five filers, IBM, miles ahead. So hand it to IBM. They really got on this early. They have a huge number of patent filings on quantum computing related technologies. Uh, Second place is Microsoft, and then closely followed by Baidu and Benyuan Quantum in China. And then coming in fifth is Google. And once again, the one Canadian origin company here, D-Wave, did not make the top five. They're right behind Benyuan at number 6. So that's interesting. I mean, IBM's lead is interesting here. It's interesting to see some of these countries and broken down by region of origin. sort of some of these companies, countries, whatever. Um, and we're going to see you probably see some familiar names on that list if you follow the industry at all. Okay, so now the state of the law. So we don't have a lot of jurisprudence here yet, but we do have some cases out of the Patent Trial and Appeal Board, the PTAB, in the US. And I do want to give a shout out here to a great blog post that does some analysis of these cases. But we're going to do our own analysis here. And I think we'll come out of this analysis with some interesting insights into what we ought to be doing and not doing as patent practitioners. I hope, maybe. So, from the top, these are in chronological order. The first is Ex parte Ashikmin from 2017. And this was a 101 challenge. So, challenges non-patentable subject matter. And this one passed. So that's good. Good sign. You know, it's always encouraging when something gets by 101 analysis. The second case, Ex parte Naife in 2023. This was a 112 challenge on two different grounds. It was the examiner deemed it to be indefinite, the claims to be indefinite, and also the full scope of the invention not being enabled by the specification. The board agreed with the examiner on the enablement thing. This was struck down for not being properly enabled, although the indefiniteness objection was reversed. The third case, also 2023, Ex parte Hastings. This is another 112, and this one got through, was deemed to be fully enabled, even though it was a technique that could only be performed on a computing platform that did not yet exist and was purely theoretical. So that's interesting. So we'll take a look at that case in a minute. Ex parte Bowman, another 2023 case, another 112 case. Here, sadly, not enabled, just like Naife. The board also deemed the description to be insufficient. And there was also an indefiniteness objection, which did get reversed here. But Bauman was out of luck. The next case, Ex parte Cow in 2024, was a 101 challenge, which passed, and a 112 challenge, which it also passed. So the examiner was reversed on both grounds. Cow got the patent. That's an interesting case. We'll take a look at that. Finally, Ex parte Zhang, just last year. This was a 101 challenge, and here the board agreed with the examiner. Now, this is a case that did involve something that could reasonably be called maybe financial technology. Maybe it's not that big a surprise we have a 101 rejection, but I gotta be honest, I don't love this case. We'll talk about that in a minute. So Ashikman from 2017. Let's take a look here because these are all actually interesting case studies in what people are doing and what they're getting away with or not. So this one deals with error checking for qubits of a quantum circuit. And we've got the claim over there on the right, and it's an apparatus. They've got an input register and auxiliary registers, a quantum circuit, a plurality of detectors, and then we have this wherein clause at the end, wherein the quantum circuit is configured to form the transformed preset states such that the produced values measure bits of the syndrome of the physical state and such that at least one of the produced values measures a parity check bit for the measured bits of the syndrome. Parity check bit, right. They're doing error correction. Interesting. So they are doing error correction for a quantum computer here. They've sort of claimed how they're doing it. And the board says, this is not 101. This is not an abstract idea. The claims recite specialized hardware configured for a specific quantum measurement task. And what the board says is quantum processing using quantum bits or qubits and measuring physical states and syndromes associated therewith may be esoteric technology, but this does not make the claimed invention abstract or lacking in utility, particularly when we view the claim as a whole. Okay, 101, they are improving the quantum computer, passes 101. This is very encouraging, okay? Ex parte Naife in 2023. So this is all 112. and unfortunately was found to not be enabled. So what we have here is this multifunctional quantum node device. It's got this semiconductor vacancy qubit structure, this quantum memory nanowire, superconductor qubit logic circuit, and it's an interface for computing or quantum entangled networking. And unfortunately, the board found here that the specification did not enable the full scope of the claims, whatever that means. I don't know how you do that without an infinitely long specification, but the law says what it says about this, and the board, goes into some detail in their affirmance of the examiner's position in saying that only two specific examples are fully described in the spec. One of them uses a diamond substrate, the other one uses a silicon carbide substrate. And they say, the person of ordinary skill in the art to practice any embodiment of these claims outside of the scope of those two described examples would just have to engage in too much experimentation to, implement the full scope of these claims. Okay. But they reverse on indefiniteness, and this is actually a little bit encouraging. So they reversed the examiner's indefiniteness finding. They said that these terms like semiconductor vacancy qubit structure, semiconductor, nitrogen vacancy center, that all these terms would be understood by the person of ordinary skill in the art. So that's good. They're acknowledging that there are people who are of ordinary skill in this field and that they have terminology that you can use in your claims that those people would understand. Hastings, 2023, a method performed on a quantum computer. This one was a 112 rejection, and it was fully reversed, even though the claims are directed to an after-arising technology, specifically a fault-tolerant quantum computer. So the examiner had said in the 112 rejection that a large fault-tolerant quantum computer is more than a decade away. But the PTAB says, no, it's fine. This invention is, in fact, enabled. They say, we agree with appellant to now say that the appellant should have disclosed the fault-tolerant quantum computer, which on this record did not exist as of the filing date and whose future existence is purely speculative, quote, would be to impose an impossible burden on inventors and thus on the patent system, citing Hogan. Okay, interesting. So you can fully enable the full scope of your claims, even if the platform you're talking about, which is going to implement these, doesn't exist outside of theory. Okay, interesting. Square the circle on that one. You guys can go and read those cases yourself if you want. Ex parte Bauman. This is January 2024, claiming a machine learning technique where the final step is performed, quote, using quantum entanglement. Look at that claim. So a method where you're selecting layers from these machine learning models. You're concatenating these selected layers to form this core deep learning model. You're training it. And then this last clause, synchronizing by the computing device layers in the core deep learning model with the layers from the plurality of external deep learning models using quantum entanglement. Now, I'm sure the dependent claims give a lot more resolution there, but maybe I can see where the board's coming from here. So they say, first of all, this is not enabled. You haven't enabled the full scope, too much undue experimentation to implement this quantum entanglement. Okay, I mean, maybe there's not enough detail in the spec about how quantum entanglement works or how you might implement it. Okay, so that's interesting, and we'll come back to that later on talking about tips. They also said that the description was insufficient. They basically said, I mean, reading between the lines, I think, that this is describing and claiming a desired result and not how to achieve it. So, using quantum entanglement, just quantum it, you're good. I mean, I'm being flip, but I think that's what the board's position, that this was like, wouldn't it be nice if you could use quantum computing to solve this problem? But saying, wouldn't it be nice is not enough. So yeah, so there's an insufficiency issue. There's a lack of enablement issue. This is the position of the board. But again, they reversed, at least in part, on the indefiniteness stuff. There was an earlier version, I think, of these claims that said synchronizing these layers using entanglement, that was deemed to be indefinite because the board said, well, what does entanglement mean? There could be non-quantum types of entanglement. Okay. But on the other stuff, the indefiniteness objections were reversed. So we have a pretty good track record so far on indefiniteness, if not enablement. Cow. This is about a year ago, February 2025. So this was a method for solving linear equations that's performed on a classical computer and a quantum computer. And if you look up at this this claim preamble here, a method for preparing a quantum state that approximates a solution X to a linear system of equations for this matrix and this vector. So math, this is math. They're doing math and they get a 101 rejection, maybe not surprisingly, from the examiner, but the board says, no, this is fine. This is an improvement to quantum computers. In particular, we agree with appellant that the additional element integrates the abstract idea of mathematical relationships into a practical application of enabling noisy quantum computers, which have limited circuit depth, to practically solve linear systems, a technology improvement. Okay, you are improving how the quantum computer works or how you can use it so that the computing system as a whole, at least, is improved. And this is one of the ways you get past 101. Okay, that's great. Very encouraging. There was also a 112 rejection, which again, the board reverses. They say that the claims and the description provided sufficient description to support the full scope of the claims. And in fact, the board sort of has a comment saying, the examiner rejected under 112 nominally on the grounds of insufficient description, but really it sounded more like an enablement rejection to us, and they sort of performed their analysis on that basis. So we're really, even though this was formally an insufficiency rejection, we're seeing a lot of objections on the grounds of lack of enablement. Let us keep this in mind going forward. Okay, and now the last case of the bunch, and the one that I find a little troubling. This is just a few months ago, ex parte Zhang, a method for calculating risk using a quantum computer. So this was a 101 challenge, and the board upheld the rejection, saying that calculating risk is an abstract idea and that it is not integrated into a practical application. Let's look at this claim. A computer-implemented method for calculating risk, where we use a bunch of processors and we receive these deterministic values for a bunch of factors. We generate, now this is the quantum step, generating over an evolution time interval starting at the first time, respective stochastic quantum values for each factor from the deterministic values, wherein each factor is represented by a respective n-qubit quantum circuit, wherein each qubit represents a risk level. Okay, that you're mapping your classical digital data here that you just received to how you're going to set it up in the quantum circuit with these qubits. You're combining the quantum values for the factors into an intermediate quantum risk value. You're modifying this intermediate quantum risk value according to some classical parameters, and then you're generating a final stochastic quantum risk value. I don't know. Sounds pretty practical to me. Calculating risk is something people have been doing, well, formally for at least hundreds of years. Something you have to do in a lot of different industries. Seems pretty practical. We joke a lot when we work on this quantum computing stuff that it's only a matter of time before someone gets a 101 rejection characterizing some quantum computer that doesn't exist as, purely generic, conventional computer. And I don't think that either the examiner or the board in this case said that the as yet non-existent quantum computer was purely generic and conventional, but I'm not sure they're not saying it. Um, like we may have now already jumped that shark, which is a little depressing. But anyway, we have the other cases, that did pass 101. That gives us some suggestions of way forward here. And so let's see, what can we extract from this case law and from some other stuff we've seen? What are the actual tips? And a lot of this is speculative, but a lot of it is, I hope, practical advice. So the big theme that we saw emerge there is enablement is a problem. So this is a new technology area. Um, you are not going to have a lot of examiners or judges or juries that know anything about this stuff. And so you do not want to skimp on your description. You want to dump the textbook in there. Your specification should have the aim of educating a patent examiner or a court about what this technology is all about. You want to have a very detailed background discussion. Well, here's how you do it. You have these registers that have this matter in quantum state. You have these control systems, and they're sending these signals, and then they're talking to a computer, and the computer compiles this software, and that software is then going to control the analog hardware to da 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 da. So you lay out the whole stack, tell them how all the pieces fit together, and then you tell them what your invention is. Um, so this question about enabling the full scope of the invention, the thing that was the downfall of both the Knife-Fay and the Bauman patent applications. What do you do here? You just want to, I don't know, like I said, I don't know what it means to enable the full scope of a patent claim. Um, but I guess what you need to do is describe as many implementations as you can, along with any general principles that would help people to implement the other ones that you don't specifically describe. And then, if necessary, you might want to think about trying to limit the claims to those implementations that you've fully described. Um, surprisingly, maybe you can apparently claim methods that require computing platforms that don't exist, like in Hastings. So I don't know, there's something going on there. Maybe it's worth taking a look at the spec of that Hastings application, compare it to the Knife-Fay and Bauman specs, and see if there are any lessons to be drawn there. Okay, so subject matter. 101. So one question is, we talked about this stack with all these different moving parts. And, a lot of these technologies have applications outside the realm of quantum computing. It's a refrigerator, or it's a piece of analog hardware, or it's a photonic waveguide, or whatever it is. And so you might want to think about saving the quantum specific stuff to put in the dependent claims so that you can get broad patent coverage on all applications of this device, or this technique. And then specifically, have the quantum stuff in the dependent claims as a fallback. But it's worth thinking if, as you go through your 101 analysis, whether the quantum stuff is going to help you, that you still do run the risk, even if it's clearly being carried out on a quantum computer, you still do run the risk of being rejected if the algorithm itself is deemed to be something that gets you zapped as abstract under 101, like the calculating risk algorithm in Zhang. But if you have an algorithm that can actually improve the functioning of the quantum computing platform itself, then you may be okay. And I mean, in Cow, the claim was very, very math heavy. It was all kinds of math, 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 math. But that math made the quantum computer work, and that's an improvement to the computer itself. So that got them around the 101. Okay, inventors, working with inventors in this field. So you remember that slide from earlier where we saw that red university line taking off into the stratosphere. So the truth is, whether you're working with inventors, whether you have a corporate client, university client, your inventors are going to be academics. They're all going to have physics PhDs, like my esteemed colleague here. And so, you just, when you're working with the inventors, you want to think about that and you want to steer them and remind them, to kind of avoid the sort of style of academic publishing versus drafting a patent application. And I mean, the first thing to bring up again and again is public disclosure stuff. Make sure that they're not about to publish a paper on this stuff or talk to anyone about it. You also, when it comes to background citations, you don't want that 100 reference bibliography of everything tangentially related to the space that, each of those 100 references are going to have to be hunted down and obtain a copy and dump them all into an IDS. You will want to limit it to the things that bear some possible relevance to the patentability of this specific invention. So a bibliography in an academic paper is not the same thing as a, prior art search or an IDS. And then just generally sort of writing style and voice, a patent application, you want to police the language for stuff like we did this and we did this and right, you want that view from nowhere voice of a patent application. Um, so those are some ideas for working with the typical quantum computing inventor. And then the another topic to think about is conflicts and client management. So as more and more companies are working in this space, um, you're going to have a quantum computing client, and then someone's going to walk in the door of your firm and they're going to say, I'm doing quantum computing. And while you want to be alive to the potential for conflicts arising, it's not necessarily going to be an issue because this is this hugely heterogeneous collection of discrete little technologies. And one company working in quantum computing may be very well be working on a part of the stack that is never going to carry any chance of overlap with what another company is working on in another part of the stack. Um, that being said, as always, I mean, I don't have anything original to say about how you manage potential conflicts of interest, but just, to be judicious in managing your clients and in managing potential conflicts as they arise or hopefully before they arise. Okay, government regulations. This has been a big problem that we've run into a number of times. Quantum computing and quantum cryptography in particular are almost, per se regarded by the US government as being germane to national security. Uh, and so your clients are likely, your patent applications are likely to get a lot of scrutiny from the government. And you are going to want to be familiar with all of the security clearance procedures, foreign filing licenses, export control. You're going to want to really make sure that you know the citizenship of all your inventors, where they live, where they were when they were working on this invention, um, and you want to make sure you have all your ducks in a row for all that stuff and that it's properly documented and that you haven't run afoul of any of those regs. And then after you've done all that and complied with everything and everything is in tip-top shape, then get ready for some truly staggering delays because stuff will get flagged for national security review, and you are going to have clients who want to file in other countries, and 12 months will pass, and then 30 months will pass, and sometimes you're going to find that no one has gotten around to looking at the case and giving it the green light at the USPTO. And so you're going to spend time in limbo, and you're going to want to talk ahead of time to your foreign associates and figuring out what they can do in this weird circumstance where a case nominally is allowed to be filed foreign, but there's some box that hasn't been checked. And anyway, you're going to have to improvise. So it's a lot of seat of the pants, a lot of coordinating with foreign associates and talking to the patent office and trying to figure out what you can do to stay on sides of all the regs here while not unduly prejudicing your client's patent rights. Okay, so for the last section, this is like our history lesson now, where it all began. So these are some concrete case studies now of these old patents. And I want to kind of use these to explore for different parts of the technology stack. How do you actually claim this stuff? And so we'll start with D-Wave. At the bottom of the stack here, this is actually an implementation of a quantum register as a superconducting circuit, a Josephson junction, as Laura covered in our part one. So this is D-Wave up there in Vancouver, December 1999. Okay, it's a quantum computing method that involves cooling a superconducting bank and a superconducting mesoscopic island. You're implementing this Josephson junction in this structure. You're establishing a quantum state of a supercurrent at the junction. You're allowing the quantum state to evolve. And then you're measuring magnetic flux at the junction to determine a result of the quantum computing. So this is like textbook layer one, quantum register. Here's the implementation, and here's how you use it. Okay. Next layer up, layer two. So this is, we could call this enabling hardware. This is a cryogenic system, a dilution refrigerator, and this makes things very, 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 very cold. What, like 4K or lower? Lower. Laura says lower. Okay. Do I hear 2K? So this came out of the UK, Oxford Instruments Nanotechnology Tool Limited in 1998. And the point that you spend your quantum computer, your actual quantum processor in the middle of this thing to keep it very, very, very cold so that the heat does not immediately collapse all your qubits. So you've got a still, a mixing chamber, a pump, a heat exchanger. You've got an access tube which extends through the still. You got a probe, and then an aperture extending through the access tube. So this is refrigeration technology. And remember that, to work on quantum computing and quantum computing patents, you might not be a computing person. You might be a refrigerator person. There is all kinds of technology going on here. And regardless of your technical area of expertise, you are very likely to be able to get in on the action here. So up the stack, one more layer, we're now in error correction. This is out of Italy from 2000. A method for controlling a process driven by a control signal where you generate an error signal as a function of the state of the process. You generate a control signal as a function of the error signal. You generate a signal representative of a quantity to be minimized. And then you generate this correction signal, and it's calculated using a quantum genetic search algorithm. And if you look at that diagram, there's a lot of math in there. So I don't know how this would get treated today under 101, but maybe we'd be good here. Maybe this is one of those improving the functioning of the quantum computer patents. But this is an error correction patent in the wild. Okay, and then we get to the top of the stack. This is a sole inventor from Bedford, Robert Tucci, a quantum compiler, May 1998. And so this is a method of operating a classical computer to calculate a series of operations, the sequence of operations, with the purpose of applying said sequence of operations to a quantum computer comprising an array of qubits. Okay, so you're compiling code on the classical computer to be executed to control the quantum computer. Okay, so you're storing in said quantum classical computer a QB net, a quantum Bayesian net data set, which comprises all this math. Then you're composing with said classical computer a data set that specifies a bunch of matrices that describe the quantum state evolution for the situation described by the QBNet dataset. And then you're calculating said sequence of operations using said classical computer. So you sort of, it's a compiler. You're setting it all up, and then you're going to run the output on the quantum computer. So this is a great example of, how the classical computer is interacting with the rest of the stack. And then one more at the top of the stack. So this is a quantum algorithm out of Lucent. I'll remember Lucent, 1998. An arrangement comprising a data store, a processor for transforming data, a transform Q having such and such form, a transform having the form VU, where U is a unitary transformation, V is a unitary transformation, I is this matrix, I sub S, I sub T is this other matrix, which corresponds to a desired solution, and VU is any transform other than the Walsh-Hadamard transform. So, okay, maybe some negative claiming going on here, but this is, this is actually an algorithm. It's not just compiling arbitrary algorithms to be run. This is a specific algorithm that you want to execute on this quantum computer. But of course, the algorithm is being generated on the classical computer. So top of the stack, here's an example from 1998. And that actually is my last case study and the end of the webinar. So we kind of zipped through, but I don't know, do people have questions? Or did we have anything come in through the chat?
So far, we've just had one question, which was for the PTAB cases, and
Mhm.
the question was, were any of those pro se cases, or were they all represented by counsel? So I did a quick look, Tony, back onto the file wrappers there, and they were all kind of corporate applicants, so they were represented by counsel. Yeah.
Yeah, I would say just from my limited reading there, they all look pretty sophisticated.
And one other question, what do you, Matt, and I guess I will answer as well, both find most interesting about quantum computing? Matt, do you want to?
Wow, what a gimme. Um, I don't know. I don't understand any of it. No, what's interesting about it is that it's quantum computing is made up of things that are not quantum computing. I mean, it's all these bits and pieces, and they're all very clever, and they're all the kind of stuff that we work on day in, day out in our respective fields of technical expertise. But the quantum thing, is okay. Okay, to be fair, sometimes it's really quantum stuff, but I would say the bulk of the patents being filed, even if their primary application is to quantum computing, um, the innovation is at the level of just technical refinement of existing technologies. Yeah.
I'll mention briefly, just because we do have a couple more questions coming in, but I think similarly to you, Matt, for me, it's being able to see what does computing even mean? How do we go from what the physical implementation, the qubit is, to some meaningful data? And certainly that exists in classical computers as well, but I think because quantum computing is at this sort of explosion stage, all these pieces are being innovated separately, and so you can really kind of zoom in and see that process of data of going from a physical implementation to a piece of data in kind of real time. So yeah, so some of the other questions we have are any advice when foreign filing because no secrecy order is received within 6 months, but the Foreign Patent Office cannot access the priority document?
Well, the answer is no, we don't have any legal advice for you, but yeah, you will run into tricky situations. Um, Maybe offline we can talk about that.
Yes, I think you're not the only person who's experienced that, Timothy.
Yeah. Yes. Yes. Yeah, we can say that.
Yes. Um, Kevin says, how do we think about detectability at this stage of technology? So infringement.
Hmm.
Yeah.
That's a great question. I wish I had a great answer. I mean, again, a lot of it's going to depend on because there's so many pieces. You can maybe find out when someone has built a refrigerator, is selling a suspension refrigerator that copies your own. But um, if people are just doing quantum computing someday, detectability, hmm,
Yeah, I would say for yeah, different layers of the stack. Certainly, I mean, if you could get your hands on a Google Willow chip and put it under a microscope for inspection,
yeah,
you could start to see there at kind of the physical layers. And there are, as you go further up the stack for like error correction and the algorithms, those are somewhat more platform agnostic. So you could be using different quantum qubit technologies to implement those software aspects. So I think it would just kind of go hand in hand with how we have detectability for algorithms today. But there could be some clever physicists who could say, oh, this result would only happen if you were doing this type of error correction. So there's probably some clever ways for people to kind of peek under the box for the algorithm layers. So um, and then the next one, how about Microsoft has this topological quantum computing platform? So I have not really kept up with the Majorana particle physics implementation. I know that Microsoft has been doing that research for a good 10 years or so. But yeah, I think it could work in the long run. They certainly have a lot of um, room to catch up if they want to use topological these Majorana particles, which is a very complex physical thing. It's one of the less mature qubit platforms, so they have a lot of catching up to do. Matt, maybe do you want to take this one? What specific prior art searches do we have experience with um, for quantum computing? Do we do anything with non-patent literature searching?
yeah. Well, so depending on the purpose of your search, I mean, a huge amount of this stuff is going to show up in academic literature first. And so if you really want to find the earliest publication of some technique, the odds of it being in an academic paper versus a patent, I don't know, 50-50. Like, very good chance that it shows up in the academic literature first. Or that maybe that's the easier one to find sometimes.
Mhm. Yeah, I would certainly agree with that. And for I guess going back to like if we're working with university clients or um, corporate clients where the inventors are pretty academically oriented, usually we just rely on them. If they have some
Yeah.
reference papers that they're working from, then, we don't really do a patent literature search based off of, we just take what they give us from the literature standpoint.
Yeah, I mean, if you're trying to do an invalidity search, uh, freedom to operate or something, then go crazy with the academic literature. You're going to find lots of gold in there probably. But yeah, I mean, in practice for drafting and prosecution, certainly I'm relying on the inventors to tell me what's relevant. Um, Laura may have a little bit more in the way of some ideas there. But I would say in general, this stuff is so specialized and so new that the inventors are some of the handful of people in the world most qualified to tell you what's relevant to their invention.
Yep, I definitely agree with that. So thank you everyone for attending today. Our emails are open. You can email Michelle just at SLW or myself, Laura or Matt, with any questions. Again, this webinar and the slides will be posted online. A link will be emailed to you if you as you registered to attend. And yeah, we look forward to seeing your work out in the wild. So thank you.
Thanks, everyone. Thanks, Laura.